What is up, guys? Welcome to my channel. Man, I finally got my Pacer account going, and so we can read together through the government's opposition to defendant Lil Durk's application for reconsideration of detention order. Man, you guys need to see this because it makes it obvious that Lil Durk is likely, very likely, not going to, be allowed to go home. He is not going to be given bail. We'll read through this. Let's start with the names. First of all, Bilal A. Asaili, United States Attorney. He's the boss. He's the United States Attorney for California right now. Big deal. And then you have Assistant United States Attorneys. Who do we have? Ian V. Ianilo, Gregory W. Staples, Daniel H. Weiner. All right. These are the people going up against Lil Durk. These are the people who are bringing the case against Lil Durk and his attorneys. His attorneys are very expensive. These guys are U.S. attorneys, government attorneys. They make decent money, but nothing incredible, and they have to work very hard. But man, I took a peek through this, and they're doing a good job so far, from what I can tell. Let's start. All right. So this initial part is just normal stuff. Here, these attorneys, these assistant United States attorneys hereby files its opposition to defendant's application seeking reconsideration of this court's detention order. This filing is based upon the attached memorandum of points and authorities, the files and records in this case, and such further evidence and argument as the court may permit. Got through that. Signed by the attorneys, California licensed attorneys. Let's start with the memorandum of points and authorities. So this is basically their argument against Lil Durk's attorneys asking for a hearing to hopefully get him sent home, all right, so he can handle his case from home, so he can get a bail. Here we go. Defendant is charged with directing 6 hitmen to travel across the country to hunt and kill his rival, TB. Defendant allegedly orchestrated and financed a brazen murder plot that culminated with shooters ambushing TB's vehicle at a busy gas station in broad daylight, killing SR. Following a detention hearing in December 2024, the court ordered defendant detained based on flight risk and ongoing danger. So that's why they detained him. They think he's a flight risk, and they think he can present ongoing danger. So those are the main points. So the defense counsel, Lil Durk's counsel, they need to show that Lil Durk is no longer a flight risk, or that their first assessment doesn't apply anymore, and that he's no longer an ongoing danger. It reasoned that no conditions of release would reasonably assure the safety of the community, finding that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. The court also found that defendant was a flight risk based on his attempt to flee the country immediately after learning of his co-conspirators' arrests. So that is based on those flights that we all heard about. He booked a private flight out to Dubai, he booked a flight out to Italy, whatnot. But I've also heard that some people use that to see if there is basically a charge against them, if there is a no flight charge against them, and to see if the feds are coming. So some people will start booking flights to see if they're unable to take any of those flights, they know that, oh, all right, the feds are coming, so it could be that, or he could be trying to get away. I don't know. Defendant now seeks reconsideration of that order, but defendant's application fails to address any facts the court relied on when it made its flight risk and danger findings, and fails to present information that was not known to defendant at the time of the hearing and that has a material bearing on his dangerousness in flight. So let's break that down. All right, so the court relied on something to find that he was a flight risk and a danger. Now they're saying that the defense counsel have not presented any information that was not known to the defendant at the time of the hearing, and that has a material bearing. So they're saying that you're not presenting any new information that proves that he is no longer a flight risk or that he's no longer a danger to the community. Instead, the council offers essentially the same bond package the court already rejected and seeks to relitigate an immaterial issue about when certain of his violent rap lyrics were written. So, indeed, the crux of defendant's application is that he did write lyrics about green lighting someone's murder, just that it wasn't this murder. So, either way, that has nothing to do with nothing. I mean, you can't get convicted for that. They're just trying to show, to the judge, look how dangerous of an individual he is. He's profiting from rap lyrics related to this murder. But the timing of defendant's lyrics and whether or not he commercialized his violence through rap, which he did, has little to no bearing on the detention analysis before the court. See? So that stuff is irrelevant. It's not material. It doesn't, whether he did profit from it, whether he doesn't profit from it, it does not change the fact that the court has decided that he is a flight risk and that he is a danger to the community. The issue here is a narrow one. Has defendant presented new information not known to him in December 2024 that has a material bearing on whether he should be detained pending trial? The answer is no. The government respectfully requests that the court summarily deny defendant's application for reconsideration. So what they're saying is, you've not presented anything new. The same information that caused the judge to make the decision to not grant him a release pending trial is the same facts. The facts remain the same. You've not presented any new facts that show that he's less of a danger. You've not presented a new bond package that would make the situation better, that would make the judge feel better about granting him release. Instead, you're arguing about things that are irrelevant to his flight risk and his danger to the community. So now they're going to go into the details of a grand jury. All right, let's read this about the grand jury. On October 17, 2024, a grand jury sitting in the Central District of California returned an indictment charging 5 of the defendants, co-conspirators, with crimes arising from the murder, including murder for hire and conspiracy to commit murder for hire, resulting in death in violation of 18 United States Code, Section 1958A. Defendant was identified as co-conspirator 1 throughout the indictment, with listed defendants' involvement in the murder scheme, including the allegation that he told co-conspirators that he would pay a bounty for TB's murder. Okay, so I'm guessing they must have some type of evidence, something that they're going to argue is him. Someone, it might be a witness that will say that, oh, he told one of these dudes that he would pay a bounty for the murder. In the early hours, federal and local law enforcement executed multiple search warrants at locations associated with members of defendant's organization, Only the Family, or OTF, in the Chicago area, and arrested the 5 charged co-conspirators. Soon after law enforcement executed warrants, the FBI learned that defendant had been booked on 3 international flights. See, he may have been booking these flights to see whether there's a stop order in place, whether there's this order in place where he can't book flights, where he can't leave the country. And so that's actually interesting, because over here it's sort of yeah. So he knew about it as soon as those individuals got arrested. He knew about it, and he was booking these flights, including at least one to a non-extradition country. Ooh. You see that, like, they're going to present that. I mean, they've already presented this info to the judge, and the judge has already decided not to grant a bond, all right, not to release Durk. So they're not presenting any new information that would actually help Durk in this situation. On November 7, 2024, the grand jury returned the first superseding indictment against defendant and his co-conspirators. The FSI identified defendant as co-conspirator 1 and alleged that he formed and was the leader of OTF, a group of individuals who engage in violence, including murder and assault, at the direction of defendant Banks and to maintain their status in OTF. So they're basically calling OTF a gang, you know. The FSI also included an allegation that defendant commercialized his violence through rap lyrics. Now this aspect of it is where there's an issue, that what they presented to the grand jury as him commercializing violence through his rap lyrics actually was false. It was a video made by fans, right? Where he's screaming no, no, no and stuff like that. And so he's ordered detained. The court held a detention hearing and considered evidence and arguments submitted by the parties. Among other things, defendant made the same argument he now raises in his application to reopen, a claim that the lyrics cited in an introductory allegation in the FSI about green lighting violence could not be about SR's murder because the defendant wrote the lyrics before the murder occurred. Okay, during the hearing, the court addressed the matter, finding that the consistency and timing of the lyrics has some relevance, but marginal to the dangerousness issue, which is the issue before me today. Boom! Did you guys hear that? I mean, that is a very vital point. The judge doesn't give a shit, all right? It has some relevance, but marginal to the dangerousness issue. So he doesn't give a fuck. He thinks Lil Durk is dangerous based on other factors. That's not even one of the main factors, whether the lyrics were real or whether he recorded it beforehand or after. The judge does not care, you see, and he's going to go up in front of the same judge again, and they're arguing the same points again. His lawyers aren't really doing anything spectacular here, and I know he's paying a shit ton of money. Oh my God, you know, you have to understand, these are government attorneys. They don't get paid that much. Whereas he has to spend a gazillion dollars on this case. After considering the evidence, the court ordered defendant detained based on flight risk and ongoing danger to the community. The court subsequently issued a thorough written detention order. As to danger, the court detailed the allegations against defendant, including that the co-conspirators acting at defendant's direction traveled to Los Angeles, tracked, stalked, and attempted to kill TB by gunfire, including a fully automatic firearm in broad daylight in a busy Los Angeles intersection, and did kill a family member of the target who was traveling with him. The court also relied on evidence that this was not defendant's first murder for hire plot, noting in a separate matter in Chicago, defendant is alleged to have engaged in similar conduct, that he has offered money for people to kill those responsible for his brother's murder, and more specifically, offering to pay money for any gangster disciple that is killed. Okay, now that is some crazy shit. Now they're just presenting that in a detention hearing, so it's it's a bond hearing. So I guess they don't really need a lot of substantial evidence. They can just allege things like this, unless there's another indictment. As a result, the court found the material proffered by the government supports the conclusion that the defendant uses his money, influence, and power to endanger individuals who he perceives as a threat. As to flight, the court rejected the argument that defendant's significant bond package mitigated his risk of non-appearance. Among other things, the court found that the defendant attempted to leave the United States upon learning of the arrests of his co-conspirators. Wow. Okay, so he's up against Goliath here, guys. He's up against Goliath because the court has already seen this. They've already made a decision. The odds of them creating, of letting him out, releasing him based on these arguments they're presenting now, I mean, those odds are not in his favor. Defendant's application fails to offer any new evidence, much less evidence that is material to the detention analysis. So here, I'm not going to go through this because I think I already explained it to some level. I don't know, unless you guys want me to go through this, I have no problem doing that. Just, let me know in the comments if you want me to go through more detailed, even the legal arguments, the cases. I can take you guys through all that stuff. We can even look at the cases themselves. We can read the statute ourselves. We can go through all of it in thorough detail if you guys like. However, we've already read a summary of this argument, which is that, you need to present new evidence that changes the prior observation of the court. And the judge previously said that this issue that they're focusing on of this rap video made by fans, or that these lyrics he really recorded before the murder or whatever or whatnot, it's not substantial. It's not significant to his decision. It's not material. You know, he's making a decision based on other factors, whereas his lawyers are focusing in on this factor. Is it really worthwhile? I mean, if you're fighting for your life and trying to get freedom, absolutely. You want to go for everything you can get to get the hell out of there. However, he's paying a shit ton of money to these lawyers, you know? This is the government's response. These people get paid, I guess, salary. So, I mean, he has to pay. Well, from that DJ Academics interview, I guess they gave him a deal, like a package deal, maybe $1 million or something like that. Who knows? But yeah, I mean that's Lil Durk's situation right now. You know, I just wanted to make a video on these arguments because a lot of people are thinking that he might actually get bond. And when you read this and when you see what the judge has said previously, how much weight he actually gives to this issue of when were the lyrics recorded, was it a real video, in the grand jury indictment, the superseding grand jury indictment, he doesn't really care that much. And so odds are, my bet is that he will have his bail denied. He will not be given release, and that, you know, he's just gonna have to take it to trial, I guess, or make a deal or something. I don't see him getting released on bond, and so he's gonna have to fight this case from behind bars over there with Loose Cannon, who seems to be running the prison. Honestly, if you watch those videos of Loose Cannon, those calls with his wife Sharice Mills, man, he sounds like he's running that goddamn prison, isn't he? Well, anyway, guys, let me know what you guys think. I've been trying to make these videos. I hope you guys like them. Peace.